And I'm going to introduce our next speaker, Attorney Joe Suma, who's responsible for that. Go ahead.
Hey everyone, thanks for being here. This really came about the efforts of Senator Markley and Representative Sampson meeting with a bunch of people, contacting us, putting together a consortium of disability advocate groups, your group, private employees, private consumers, and the Yankee Institute is helping. And so we've put together the funds and the consortium, if you will, to proceed with the case. It appears we will probably be filing two separate suits, one for the personal care and one for the family care. The personal care attendants, that's a little further along. We have all our plaintiffs lined up, etc. We're hoping to talk today to some people who might be interested in becoming plaintiffs in this lawsuit. So one of the difficult things in a suit like this is it's not like a car accident, you know, where something has happened, you have the facts, you know when, where, how, high, and you sue. This is what's called a declaratory judgment. We have to go to the court and say, look, the governor has done something wrong, and here's why he's done this wrong, and here's the injunctive relief we would like. So to do that, you have to look at what happened and say, okay, how do we challenge this? And now who is the person that has standing to challenge this? Briefly, I think the challenges, the legal challenges, and it'll be a question and answer, so we can get into anything anybody wants to get into a little more. But the first is that and this is in no particular order, the first is that the governor simply exceeded his authority. That in order to issue executive orders, you have to have clear statutory authority. They can only be issued for certain specific reasons, and these issues go well beyond any of those statutory reasons. Second is the separation of powers, which Representative Sampson referred to. You know, it is under our Constitution the role of our legislature to pass laws. You know, the governor either signs the bill into law or he vetoes it. Okay? He has no power under our Constitution or under our state laws to pass laws of this nature. Third argument is preemption. Preemption basically says this is an area that the federal government has looked into, has legislated, and has occupied the area. Therefore, state law, you cannot intervene in this. That argument is based on the National Labor Relations Act, and it basically says that some of these groups, in both sides, both the personal care and the child care, are covered by the National Labor Relations Act. Under that act, both employers and employees have certain rights, including the right to have an appropriate unit determined, including the right to have a secret ballot election, including the right to bargain with your employer, who is truly your employer, over wages, hours, and working conditions. Their next argument is that what has happened is contrary, not only is it preempted, but it's contrary to federal law and contrary to state law. State law, basically if you're an employee in the state of Connecticut, you know, you got to fall somewhere. You're a state employee, a municipal employee, or a private employee. Okay? In the private sector, the National Labor Relations Act covers all employers over a certain size, a relatively small dollar amount, $50,000 in interstate commerce, and anything is interstate commerce today. And what our state law has, we have a little Wagner Act. Not every state has it. It was passed in the 1930s, and it basically says that anything the National Labor Relations Act doesn't cover, we do. Okay? And here's our procedures, and here's our unfair labor practices, and here's our board, and here's how it's done. So there's no employees in the state of Connecticut that aren't already covered by some law. The next two arguments are constitutional arguments. One is the right to association, and that argument is basically that what is going on here is not really collective bargaining, it's forced lobbying. That they're forcing a group of people to use a certain other group of people and pay money to them to lobby. And the last is equal protection. You know, many people with the same interests aren't allowed to vote, but are going to be impacted. Some people, you know, there's people that are impacted aren't allowed the same opportunity as other people that are under the same programs. So those are constitutional arguments. That, in a nutshell, would be the basis of the arguments and where we are at this point in time.
Very good.